Good morning, this is your Kelso Report for Tuesday, February 14th, and I'm your host, Clark Kelso. We've got cases today dealing with government law and qualified immunity, a civil rights case involving a prisoner complaint, and criminal sentencing restitution. Let's get started with our first case, government liability and qualified immunity, coming out of the Ninth Circuit. What price loyalty? Well, in the Sheriff's Department in the county of Orange, political loyalty was the name of the game. The day after his scandal-ridden third election to the position of Orange County Sheriff, Michael Corona placed on administrative leave and subsequently demoted William Hunt, a former lieutenant who had run against Corona's alleged culture of corruption and lost. Although the Ninth Circuit held in Hunt v. County of Orange that Hunt was not so high up in the department that he held a policy-making position, subject to demotion or dismissal on political grounds, the court did hold that the sheriff's decision to demote Hunt was protected by qualified immunity, since a government official in the sheriff's position reasonably but mistakenly could have believed that political loyalty was required by someone with Hunt's job responsibilities. There was a partial dissent here. It agreed that qualified immunity applied, but actually would also have held that Hunt's job placed him in the policymaker category, where a dismissal for political and policy differences would not have violated the First Amendment. Hunt loses the election and loses his job at the same time. Next, we have a prisoner case arising under the Eighth Amendment. An inmate can state a claim under the Eighth Amendment for imposition of cruel and unusual punishment only if the conduct is sufficiently serious and carries with it a high probability of severe physical or psychological injury and emotional pain and suffering. By contrast, the mere exchange of verbal insults between inmates and guards is viewed as a constant daily ritual, which, though not approved by the courts, does not violate the Eighth Amendment. In Watson v. Carter, the inmate alleged that an officer sexually harassed him in violation of the Eighth Amendment. The guard allegedly had entered the plaintiff's cell while the inmate was on the toilet and began to search him. The inmate asked the guard to leave, and the guard then approached the inmate while still on the toilet, rubbed his thigh against the inmate's thigh, quote, began smiling in a sexual contact, close quote, whatever that means, and left the cell laughing. According to the Ninth Circuit, this just didn't rise to the level of a sufficiently serious injury to violate the Eighth Amendment. On the other hand, the plaintiff's complaint did adequately state a claim for First Amendment retaliation arising out of prior complaints the inmate had filed against another correctional officer. The inmate's complaint alleged that in response to the filing of those grievances, the officer and warden took unjustified adverse actions against him, including placing him in administrative segregation and lying to the parole board, resulting in denial of parole. There was a dissent in this case. Judge Noonan agreed that the retaliation complaint was adequately stated. He would also have found that the toilet touching incident was sufficient to state a claim under the Eighth Amendment. Next, we have a case involving restitution. Now, the goal of restitution in a criminal case is to make the victim whole. And just as in the law of civil remedies, the goal is compensation for injuries suffered. And when damages become too remote and speculative, they should not be the basis for a restitution award. In United States v. Young, the defendant was convicted of a complex fraud, pursuant to which the defendant was able to secure large loans for the purchase of real property based on fraudulent information. This was a multi-million-dollar fraud. For purposes of sentencing, the government and probation office had calculated loss to the victims based on the outstanding principal balance on the defaulted loans, less any money recovered from a sale of the real property collateral. This was an appropriate measure of possible harm for purpose of sentencing. But, in fact, the actual losses suffered by the victims did not reflect this simple calculation, and that simple calculation tended to overstate actual losses from the fraud. Yet the district court simply used the same estimate for purposes of its restitution award. The Ninth Circuit held that this did not provide a sufficient basis to establish the actual loss suffered by the victims, and so it reversed and remanded for reconsideration of the victim awards. Well, that's it for today's Kelso Report. Happy Valentine's Day, and have a great day in the law.